Hello everyone, I'm Rajesh Kumar. I'm a visiting faculty at Faculty of Law, University of Delhi, India. I also have been a participant of earlier workshop that was third workshop in Haifa. So I'm coming second time for the wonderful workshop here. So my topic for today's presentation is the protection of civilians in armed conflict, a conundrum between state action and human rights protection in India. So this would be the overview of my presentation, beginning with the internal conflict in India and the affected regions. I will be showing some maps which are showing how much area is affected by the internal conflict. Then we will be discussing about legal framework, then balancing the state necessity and civilians' human rights protection. Then I will be talking about judicial response and the related challenges. Then we will conclude it with conclusion and the way forward. So beginning with the kind of armed conflict existing in India, so we have three major conflicts which are causing problem to the internal security of India, and out of these three, two are having on the border of India. So on the northeast side of India, there are certain states, 7 states in total, and out of the 7 states, certain states are facing insurgency movements like Naga movement, then Assam, state of Manipur, state of Mizoram, state of Meghalaya, and some other states in northeastern part of India. Then on the northwest part of India, there is state of Jammu and Kashmir, which is facing problem of internal security. Then in the center of India, central part, that is next slide, affected Maoist insurgency.
Focus back on the move to the camera.
There is a sign.
Yeah, you continue.
So this map shows the situation of 2009. So you can see the gray areas are affected by internal security, and the more the gray area is, that is highly affected, and the moderate areas are horizontal line, and there are areas which are marginally affected by internal conflicts. So different kind of organizations which are, we can say that non-state actors which are posing problem to the internal security are also mentioned with a state-wise list of these militant groups. So this was the situation in 2009. So now coming to the present scenario.
Next slide.
Yeah, next slide.
Or just try to click on it again. Try it again.
Yeah, now it's okay.
The clicker rolls.
Yeah. So the next map shows that 2019 scenario. So you can clearly see how the difference is. The areas affected by all kind of internal conflict now reduced. And the next map shows the areas which are affected by left-wing extremists. That is next slide, Maoist movement. So that is present scenario. But in 2005, the Prime Minister of India, Dr. Manmohan Singh, he declared that the biggest security challenge to India is Maoist movement. Because in 2004, all the Maoist insurgent group, they combined together and formed CPI, Communist Party of India, Marxist. So with this, they started challenging central authority, and they were planning to declare a separate country in the middle of India that was known as Red Corridor. The Red Corridor was, yeah. So the area which is here up to that was called Red Corridor. They were having a planning to take it to the China so that they can get direct support from China. So that was the objective of, because it is a Maoist insurgency. So Mao was Chinese premier at one point of time. So they were influenced by his revolution. So they wanted to create the same kind of revolution in India based on agrarian community revolution. Now coming to the legal framework which deals with all such internal conflicts. So there are two frameworks, one is national, another is international. So at national level, further there are two frameworks, that is constituent and another one is statutory. At the constituent level, these are the provisions which specifically deal with the peoples affected by conflict or peoples are in conflict with law and order problem. For example, Article 20 which talks about three kind of principles. First one is ex post facto laws. Second, rule against double jeopardy. Third is rule against self-incrimination. If you might not be knowing the meaning of these, then first one is there cannot be any criminal law which have retrospective effect. So means if you have committed some act which was not crime at that point of time, but now it has declared as a crime. So you cannot be tried or made accused of that act which was not crime at that point of time. Second is double jeopardy, means you cannot be tried twice for the same offense. Or if you are acquitted, then you cannot be tried again. Third is rule against self-incrimination, means you cannot be compelled to become witness against yourself. Another is Article 21 that talks about right to life and liberty. Although it looks like these are the simple words, right to life and liberty, but till 1979 they were considered very simple word, and the only thing covered under these words that physical life, not all the aspects of life. So the courts used to take interpretation in literal sense. In 1979, there was a case known as Maneka Gandhi case. The full name is Maneka Gandhi versus Union of India. So in that case, the Supreme Court of India has interpreted this provision with a word that right to life and liberty includes dignified life. And from that time onwards, I can say that this is the biggest article in the Constitution, which has included all sorts of rights, whether it is related to prisoner, accused person, or people enjoying the basic freedoms, all rights are covered in it. Then there is Article 22, which deals with the rights of the arrested people. So it provides two kinds of mechanisms. First one is related to general laws, and second one is special laws. Special laws, that is preventive laws. The first one provides three kinds of rights to every arrested person. First right is ground of arrest should be communicated to the arrested person. Second right is the person arrested must be allowed to have legal support or assistance from a qualified lawyer. And the third right is that he must be presented before a judicial magistrate within 24 hours of arrest. So these are the basic rights which are also covered in various human rights conventions. Then next part of Article 22 is related to preventive detention laws, which is special law and which can provide a kind of proviso to these rights. Means the person who is arrested under special law may not be given these rights. So that is the area which would be I would be covering under the violation of human right. So next is Article 38, which talks about that states is responsible to provide a kind of mechanism where development can be ensured at the societal level, at the economic level, at the political level. So this is a general provision which puts some responsibility on the state. Now coming to the statutory mechanism. Statutory mechanism is, there are two laws. One is AFSAPA. The full form is Armed Forces Special Powers Act. We have two laws. One is of 1958, another is of 1990. 1958 law applies to the northeastern part of India, and 1990 Act applies to the state of Jammu and Kashmir. Both the laws gives army specific powers, which I have mentioned in the following lines. Section 2B, read with Section 3 of the Act, talks about disturbed area. Section 2B provides what would be disturbed area, and Section 3 provides how that disturbed area would be notified or denotified. So the application or implementation of this law dependent on whether that area is declared as disturbed area or not. If area is declared disturbed area, then law would be applicable on that. So as per Section 3, when the area is facing severe law and order situation, then the governor of the concerned state or the administrator of the union territory or the central government may by notification declare that area as disturbed area. So it is easy to declare any area disturbed area. So the moment area is declared disturbed area, the army would get special powers, and the army is given that kind of powers because these areas are connected to the border. As I shown in my maps, you can see that J&K is here, Jammu and Kashmir. So this is having border with China and Pakistan. Then we have northeastern part of India. This is having border with China, Bangladesh and Myanmar. So these areas are having border related issues, and at the same time there is insurgency. So there are very high chances that insurgency is motivated or supported from outside actors or other states. So that is the reason that Armed Forces Special Power Act applied to these areas only. When it comes to the areas which are affected by Marxist or the left-wing extremism, they are not covered under Armed Forces Special Powers Act because that is internal problem, not having anything to do with border. So that's why the army's preview was removed from that area. So coming back to the Armed Forces Special Powers Act, it gives extensive power to the army. Under Section 4, it gives power to the concerned officer to arrest or to search, to seize any vehicle, to declare any property that is affected by that kind of activity which insurgents are usually involved in. So it gives extensive power without any check on the army. If they believe, and believe is a word that even on fake information you can find that, okay, I believe that there is chances of having some connection of these people with the incident. So in such situations, army get a free hand. Next is Section 6 of 1958 and Section 7 of 1990 Act. So in these two sections, the army is given immunity from the actions taken by them. Means whatever kind of action they are taking, no shoot, no case can be initiated against them. That is not the situation that army is completely immune from its actions. Human rights organizations generally they make allegation that with these two provisions, army is completely immune from all sorts of illegalities. But there are instances where army itself has taken action against its erring officers on the complaint as well as without any complaint. So they have proactively trying their officers, and from 1990 onwards till date, approximately 150 army officers and personnel has been convicted by army, and approximately 50 of them were without any complaint. Means the army proactively looked into their conduct and they were exceeding the power given to them, and army took action upon them. So there is a provision, but that is with the army. The army's armed forces tribunal take action against them. So there is no civilian interference. There is no power given to the courts to try these people. Next is UAPA, that is Unlawful Activity Prevention Act 1967. So this act provides two gray areas. First one is unlawful activity, every activity can become unlawful. So it deals with the kind of activity which has potential to threaten integrity, sovereignty of India. So those activities will be falling into that act. So the police officers having the power to declare that this conduct was creating a threat to the integrity of the country. So when that thing is declared, the draconian provision came into effect. And with this, the effect would be very severe, because now the person arrested under UAPA would be falling under the Article 22, Subpart 2, that is preventive laws. And for that person, there would not be access to 3 rights. Grounds of arrest, it is not necessary to inform him at the time of arrest. It is not necessary to allow him to access of qualified lawyer, and it is not necessary that he should be presented before judicial magistrate within 24 hours. So his case would be tried or taken care of differently. He can be kept up to 3 months in imprisonment without beginning of trial or without initiating of any action. So that is called preventive detention. So this law is many a time criticized because of vague and complex language that police officers or the law enforcement authorities, they usually take we can say that under the garb of that particular conduct is anti-national, they can arrest. Then there is section 43 and section 15. Section 15 talks about terrorist act, and 43 talks about if any person is involved in act or action of terrorizing, then his property as well as his personal search can be made and he can be arrested. Not only this, his property can be seized. So this stringent law gives authorities special powers which, whenever is exercised in excessive manner, can be criticized or can be called a kind of violation of human rights of civilians. Now coming to international instruments. So at international level, there are 4 conventions of Geneva, and the common Article 3, which deals with the armed conflict, and additional protocol to 1997, that is also dealing with the same issue. But the problem is the government of India has not approved or ratified additional protocol. So this is not applicable on India, because government of India consider that the conflict is not armed conflict. And unless and until you declare it as a armed conflict, till the time it cannot be covered under the provision of Vienna Convention. Reason being for not declaring armed conflict, because it will attract the international intervention. Whatever may be the pretext, but it would be allowing international actors to make some comment. So India considered it as an internal matter and a threat to internal security. So that's the reason they have not declared it as an armed conflict. Then there are other conventions which are dealing with that. So UDHR, Universal Declaration of Human Rights 1948. So certain provisions which I have mentioned in this list are dealing with certain rights of the civilian. All these rights, whether they are covered in UDHR or ICCPR, all these rights are already incorporated in the Constitution of India under Part 3 of the Constitution, that is known as fundamental rights. So these are equally available to the civilian as well as to the people who are fighting in that conflict, specifically the non-state actors. Now coming to the effectiveness of protection mechanism. No doubt there is mechanism available, but that mechanism is, whether it is sufficient or not, dependent on how many kind of cases or what kind of cases are coming under the scanner of violation of human right of civilian. So in my paper, I have covered certain allegations of killing of groups, of disappearance of the people, finding of unmarked grave. So all these are becoming allegations against the security forces that they have been involved in such activity, but there is no evidence which can pinpoint that it is done by the state or the army. Because the situation is that the armed groups, they also try to do certain activity in order to bring people in their favor. So if civilians are supporting government, then they would be target of armed groups. And if they are not supporting, then the army or the state government will keep eye on them, whether they are having connection with these people or not. So in both ways, civilians are facing the fire. Now coming to the balancing the state necessity and human rights of civilians. So civilian protection, whenever it is maintained, it increases the public trust and help in establishing the state legitimacy. And oppositely also, when there is challenge or there is violation of human right of civilian, then it will decrease the trust of the public in the government and ultimately leading to the kind of fishy-various activities which may result into fragmentation of that particular country. So we have allegations, as I mentioned, that allegation of extrajudicial killing, disappearance, excessive or disproportionate force. So there are allegations by human rights NGOs. But I could not find in my research that these allegations are based on some substantial evidence which can pinpoint towards the army. Because it is a conflict, and if the armed group is killing these people, then how would you find out? Moreover, on the northeastern part of India and the northwestern part of India, both are having international border. If these people who are disappeared from the public, if they are moved into another country, so they cannot be declared or cannot be called that army has taken them under defense. So that is a problem where nobody knows where are these people. And there are unmarked graves. So that is also a situation where exact proof cannot be found who is involved behind that. There are allegations against army, which I have covered in a case which I will be discussing in the judicial response, where the judiciary or the Supreme Court of India has directed the Central Bureau of Investigation, that is CBI, one of the premier investigation agency in India, to investigate certain people's disappearance. So both sides are there, that on the one side, army or the concerned authorities are taking extreme actions, but on the other side, there is no proof that who is killing these people. Sometimes they fall in the conflict zone. Sometimes the terrorist is hiding in their home and army is declaring you need to come out, and they are putting a gun on the head of the civilian. So in such a situation, on the one side, army is doing its due job or duty to declare before firing, to announce that come out, we are not going to kill you. On the other side, that person is in a situation he cannot come out, that civilian, the homeowner. So when army is firing at the home, there are chances of casualty of the members of that home. So another situation where we can look differently, like in state of Jammu and Kashmir, there are many instances where the army personnel are meeting the family of the terrorist or the incident and asking them and also taking them with them to persuade the terrorist to hand over or to surrender. So that is also a positive development. Instead of eliminating people, they are trying to bring them into normalcy or mainstream. So I have covered certain case studies. One is, although I have not covered it in detailed manner, but a passing reference I have covered it. Like 3 major case studies. First one is Operation Blue Star, that is related to state of Punjab. And in state of Punjab in 1984, central government initiated a armed action against certain militants who were occupying Sikh shrine in Amritsar. So that is nowadays known as Golden Temple. So that militant group was having lethal weapons with them, and they got all the weapons from the cross border, that is Pakistan. So in such situation, they were using the lethal weapon. On the other side, army was facing a kind of conundrum that should they use the lethal weapon, because that is in an area which is surrounded by civilian population. So in such a situation, quite a large number of people died. And after that, even the Prime Minister of India, Indira Gandhi, was assassinated by her guard, who were belonging to same group, having affiliation to same group, which was occupying that shrine. So after that, approximately for 10 years, the state of Punjab was boiling. And from 90 to 93, it remained under a kind of system which we can call police state. And then only they were able to clean out all the militants from the state, and the peace was reintroduced. But while doing so, many things happened, many actions were challenged, that there are people still who are missing from their family. No dead body was found. So there are allegations that the police forces went to any extreme, that they took people, they killed, and they thrown away their body. So these are allegations, but again, there is no proof who had done all these things. Next is Manipur and Assam, Armed Forces Special Power Act. So in state of Manipur, it remained for a long time that whole state is under the army's jurisdiction due to Assam. So whenever there is doubt or any information, or there is counter-insurgency operation going on, in those situations, the civilians are the very easy target. They cannot enjoy their daily life. If the children are going to school, and in case militants are moving from that area, so army is getting some input, then they are going to take action. For example, if army is moving from that area and the militant are planning to attack, they will not take care of the civilians. There are many occasions where the army got wrong input, and because of that, they fired at a bus full of civilians. So that create a kind of situations where that allegation found some substance. Next is state of Jammu and Kashmir. So it has two stories. First is pre-2019 and another is post-2019. Because pre-2019, the state of Jammu and Kashmir was having special status in India. Nobody could have chance to get to buy property in state of Jammu and Kashmir. Nobody was having any right in that state who is not resident of that state. Even certain tribes were not given equal right in state of Jammu and Kashmir. And one of the tribes' name is Gujar Bakarwal. So that tribe was living in the state since independence, but they were not having rights. They were not given the status of resident. So there were many problems with that special status. At one point of time, it was necessity, but later on it lost its relevance and became itself a kind of inhibiting law, which was stopping state from to take any welfare-related action. So in 2019, it was removed or repealed by central government. Post 2019, there are allegations, and that is having quite a good substance behind the allegation, that in the state of J&K, a curfew kind of situation remained for around 2 years. No internet activity or no internet access was available. So, and many political leaders were detained. So that situation shows the grave condition for that 2 years. But let's look at what the government has done in these 2 years. Prior to 2019, whenever the election was taking place in state of Jammu and Kashmir, not a single individual was having that freedom that I will not be attacked. They were feeling or facing a kind of security threat. They were not coming out to vote cast vote. And the percentage of vote was 6%. After 2019, the percentage of voting increased to 66%. So we can see the kind of effect came out post abrogation of 370, that is Article 370, which was giving special status to state of Jammu and Kashmir. Now coming to balancing operational effectiveness and right to protection of civil human right of civilians. So whenever the army or the concerned paramilitary forces which are deployed in the areas affected by left-wing extremism, so whenever they are running their operations for counter-insurgency, in these operations we cannot in advance decide what would be the reaction of the state or reaction of the other party. So state's reaction dependent on the reaction of the militant group. So operational effectiveness has increased a lot. Earlier, the army or the paramilitary forces, they used to take action. They were not aware of that whether they are violating human rights or not. Let's take an example. In 2019, the army was deployed in one of the area of state of Jammu and Kashmir, and there the locals were throwing stones on army. So army was having two options: either to respond to these attacks, even if it is small attack. Then also army was having an option to take action. But one of the officer of army, what he did, he took one of the civilian, he tied him on the jeep of that army, and now the civilians stopped throwing stones because they were feeling that if they are stoning, then it would be their own brother. But on the other side, it was a violation of international human rights laws that you cannot treat in that. So because that army officer were not having that training or that knowledge that they are violating some laws that are not to be done by them. So they were doing that. Now they are getting information and knowledge. Now they are changing their strategy and becoming more proactive whenever they are initiating any operation. So present day, we can say that a big improvement has come because they are also under the scanner of media and all sorts of people who are working for the protection of human rights. So because of that also, that their operational effectiveness has increased. Now coming to judicial response. So there are certain landmark cases which were dealing specifically with these issues or the violation of human rights. First one is Naga People's Movement versus Union of India. It is a 1995 case. In that case, the Armed Forces Special Powers Act was challenged, and the Supreme Court held that we need certain laws which can deal with special situations. So the Supreme Court upheld the constitutional validity of AFSPA, but at the same time, it issued directions so that it don't become a tool for violation of human rights. Another case is Extrajudicial Execution Victim Family Association versus Union of India. In this case, Supreme Court issued direction to the CBI, that is Central Bureau of Investigation, to look into the issues where around 1,500 people were, we can say that they are not found. Where are they? Where are they missing? So for that, to inquire about it, whether they have been killed by army, whether they have been taken hostage or become militant with the militants. So in order to find out the truth behind that allegation that they have been killed by army, the Supreme Court issued direction to the CBI. Then there is another case that is Masuda Praveen versus Union of India. In this case, one of the party went for compensation for the killing of their family members. But the Supreme Court held that yes, that can be a ground for giving compensation if human rights are violated. But the party was not having sufficient evidence which can connect whether that person was, that family member of her is killed by or was killed by the army. So due to lack of evidence, the Supreme Court denied the compensation. But there is another case, that is Thangzam Panorama Devi case. In that case, the Supreme Court issued compensation direction to the state that you need to compensate adequately the affected party. Then there is certain provisions which give Supreme Court or the High Court special power to compel the executive authority to behave in a certain manner. For example, Article 32 and 226. These are the constitutional remedies. Under 32, any person can go directly to the Supreme Court if their fundamental rights are violated. Under 226, the same right is available before High Court of India. Then Article 141, which says that any decision or any matter decided by a Supreme Court or High Court would be having a precedency value. And India being a common law country, the precedence means it would be having equal force to the or equal force of law. Then there is Article 142 that talks about complete justice. Then when there is gap of law, when there is vacuum and law is not available, the Supreme Court can issue direction or can issue guideline, and these guideline would be considered law till the time there is a law enacted for it. So that these three articles provide enough power to judiciary to compel the executive authority to behave in a particular way. Because if Supreme Court has issued some direction or High Court has issued some direction, if the concerned authority, whether it is military or civilian authority, they are not complying with that, then that would be considered contempt of court. And under contempt of court, any executive authority can be compelled to behave in a way which judiciary wants. Now coming to challenges, I found in my research that these are the challenges which are creating or continuing with the conundrum between state necessity and protection of human rights. First one is distinguishing militant from the civilian population. So when the civilian are or the militants are mixed with civilian population, it is hard to distinguish. Even the family member who has become a militant, how to differentiate unless he has been designated as militant. And if he is just a sympathizer, then also he is a criminal. Because under this special law, if the concerned authority, whether military or police forces, having reason to believe, and reason to believe can cover n number of cases. If there is possibility of having connection of that person with previously known militant, then also it is a reason to believe that he has joined that militant organization. So in such situation, it is hard to distinguish between these two groups. Next is lack of proper training in human rights for security forces, as I already mentioned, that they were not having sufficient training. But at present, the military is having a human rights cell. And that human rights cell is part of military's organizational structure. Not only this, all the officers are required to follow do's and don't do's in times of operation for counter-insurgency operation. So this is making things better. Then next is oversight and accountability challenge. There is no standalone or independent authority which can keep an eye on the action of the security forces. So only the security forces are taking action against their officers, against their personnel. So that is another challenge. Now coming to conclusion of the presentation. The armed conflicts are changing its nature. Initially, it was based on setting the narrative. For example, if you look at the map of conflicts in 2019 or 2009, you can see that these areas, which is in almost central of India. So here, the people of these states are mostly tribal. And in tribal area, the government was trying to take the developmental activities. And the militant that those CPI Maoists, what they were doing, they were destroying the infrastructure so that government don't provide them basic facilities, basic amenities, And the more they are deprived from the government facilities or welfare means, the more are chances that they will be affiliated with them. So keeping them in a deprived condition. So that was one of the strategy initially. But now the developmental activities has increased. The security forces are, instead of fighting with the militant group, they also put their focus on protecting the developed infrastructure. So that is helping them to bringing the sympathy of the locals in their favor. And now the locals are disclosing all the whereabouts of these militant groups. So it is helping the government and security forces to bring peace in these areas. Just finishing. So legal framework, as I already mentioned, that it is having very wide language. All kind of things can be declared as a kind of severe challenge to security of the country. It would be decided later by the judiciary whether that serious or that threat or that danger was serious or not. But till the time that person would be facing the judicial mechanism or the trial. Next is the conundrum, as I mentioned, it still continuing because till the time there is conflict, the conundrum will remain there. Judicial role in addressing conflict. Yes, judiciary is doing the due job, but there is problem with the doctrine of separation of power. Judiciary is not having expertise in running the operation of counterinsurgency. They are sitting at a place, they don't know how to deal with the situation on the ground. So if they are entering into all these things or putting stay on the action of the government, then they may become one of the reasons of spread of militancy or insurgency again in these areas, which are secured now by the state authority. Next is state prioritization of the security versus human rights. I already covered that. I have made certain suggestions. A comprehensive approach for legal reforms is required. Then AFSAPA should be amended or reviewed so that an oversight or transparency can be included.
Pick your favorite two suggestions.
Okay.
You have 13.
So what I would suggest, and even certain retired military officers also suggested, that there is need for civil military doctrine. So that would help in resolving the issue of human rights violations. Because the civilian authority will be working side by side. And up to some extent, the government has started doing that thing. Because in certain states, for example, in state of J&K, Jammu and Kashmir, besides military, paramilitary forces as well as the state forces are together working. So they have a kind of communication with them. So first the state police forces are sent. Then to provide them extra cover, there is paramilitary forces, that is called CRPF, Central Reserve Police Force. And then army can come if the situation is going to extreme level. Thank you.
Rajesh, thank you for your very comprehensive presentation. For everyone, as you all understood on the basis of this presentation, it just looks at various mostly internal situations across India that have arisen since 1949, when following the notorious partition, India became an independent state, a nation state. This coincided, not coincidentally, with the development of relevant laws. 1949, the Common Article 3 in the Geneva Conventions. As I read in this paper, India ratified the GCs in 1950. Looked up, I found out that it was domesticated, so implemented in 1960. Of course, the title refers to human rights law, but human rights law, other than maybe the Geneva Convention and the Refugee Convention, the Declaration on Ben, binding only being developed in the 1960s and beyond. And this, and that makes it difficult now in responding to your paper, because I read your paper and I wrote my comments. And one of my key remarks was something that you have addressed in your presentation, because you had a very comprehensive presentation. But I was reading the paper, kept thinking like, oh, but what is the situation like in India? Of course, if you were just to write for Indian readership, with, what is it, 1/8 of the world, you still have a fairly large amount of persons that you can reach. But if you want it to be understandable for those who are not versed in the domestic situation in India, it would be important to add to your paper that what you have now addressed in the presentation.
I updated some certain parts.
Because that was missing, really, what are the laws that you are actually looking at. In addition, there are quite a few things that I had to look up online to just know what you were writing about, factual situations that I'm just not aware of, and someone better with better understanding of the local context may know what Operation Rhino was, for example, something refers to, or Operation Green Hunt. A concept of fake encounters, which you refer to, which is a specific problem apparently in the military operations. And I think what would really be beneficial for readers, and what would assist your paper, if you can add to this rich overview that you give from all the different situations, the stuff that those outside India may not be aware of, but would be interested to know about. So what is then the legal framework applicable to that situation? What is that actual operation which you can't immediately find out about online? Of course, Wikipedia gives a lot of answers nowadays, but still. So I think that would really be helpful to integrate what you have in your presentation now, but what was missing from the paper. Now, if I look at how you structure the paper and how you, and again, this was so the slides about the legal framework that I was missing in the paper. What I was specifically wondering, and you addressed it now in the presentation, that the government does not call this situation armed conflict, but you do, at least in the title. Yeah. But you're not necessarily clear for all the individual situations or case studies what you consider to be the applicable legal framework. Of course, whether something is a non-international armed conflict, it's a factual test. So it doesn't matter what the government says. But is that a situation that you consider to be a non-international armed conflict? Is it part of just law enforcement? You refer to Kashmir, but then you also indicated a lot of cross-border activities and things that may or may not meet the overall control standards from by Pakistan over certain groups, which would then internationalize the conflict, and then yet another set of rules would be applicable. So that I'd be interested in, and I think that would be useful for any reader, for you to more clearly say how you classify a certain situation, and then because of the classification, the applicable legal framework follows. And sometimes or the terminology also becomes relevant. There's no combatant status in a non-international armed conflict. And if you don't specifically say whether you consider it an international or non-international armed conflict, I'm left wondering, do you consider it international because you refer to the word combatant, or do you accidentally refer to the word combatant whilst you actually consider it an internal situation? So I think it would be useful if you more clearly say what you consider to be the legal classification of the situation, and then from that you can take the different laws. And there, well, you had your slide about the different articles of the Constitution. Definitely also integrate that in there. But what I, as a non-Indian reader, would also be interested to then find out in a paper like this, whether India is a dualist or a monist country. I looked it up, it appeared to have been clearly dualist, but it seems to become more monist now. And that's an interesting development, but also affects the applicable legal framework. So these kind of things, I think, are good to integrate. And what, as a general comment, I think would be good if you sometimes more clearly just say what you think. There's a number of, in the case studies, you highlight criticism by NGOs such as Human Rights Watch, Amnesty International, and then you at certain places indicate that, but there's measures taken and the situation is better now. One specific aspect of that is that the positive kind of side is generally based on one specific source. Yeah. So it might be good to try to differentiate there, or to have more sources that say it's all okay now versus the sources that say that it's was problematic. But you highlight the different views, but what is your view? So to bring in more of yourself. For example, you referred in your presentation, but also extensively in your paper, you referred to the Armed Forces Special Powers Act. When we get to your conclusions, because you say it should be updated, then I understood that it seems that you consider there's a need to do so. But throughout the paper, I was left wondering, what do you actually think about the Special Powers Act? Because you give different views on it, by the views that say that it's very problematic, views that say that it's okay. But it wasn't until the very end that implicitly I understood, or that you consider that there's a need for change. And I think that's a general comment that try to just be more clear about your views in it, to not leave the reader until the recommendations in order to find out what you actually thought about the matters. As to a line of reasoning that you discuss, the conundrum that you talk about, I find it difficult to see it as other than maybe when it's purely the national laws. But if you look at the at IHL and international human rights law, I find it difficult to see it as a conundrum, in the sense that, especially international humanitarian law for non-international armed situations, it is written in such a way that it allows the state to take the necessary action. If in practice, because you also have your practical law, you say, okay, it's difficult to distinguish, etc., and it is, and there's not sufficient training. That in practice there may be problems, doesn't mean that the laws themselves are creating the conundrum. And then one additional comment: you had your slide very clearly where you talk about the Supreme Court. Integrate that also, because that was clearer than in your paper. On there, one specific comment is that you use the word judicial activism certain times. Someone who also sits as a judge, I don't like the word judicial activism, because if a judge applies the law, it can't be activism, it's applying the law. But there also, I think it would be good to just more clearly say what you think. Do you agree with the decisions? Because then the wording used, judicial activism, makes me think that you actually don't agree, or that you think it's problematic. But then when I come to your conclusions and I come to your proposals, and I'm like, well, actually, I think he thinks they're doing a good job, the Supreme Court. So I think that's my would be my overall comment. Make sure that you integrate what you gave, the information you gave to us now in the room, what I was missing in the paper, and just say what you really think. Add your view to the various sections. Thank you.
We're trying things here as well. This one is the person of the or the speaker. Okay.
They will have to be quite close to the.
Okay. So if you have questions, please do let me know. In the meantime, I have a couple of questions. You, first of all, a very interesting presentation. Thank you for that. I was wondering, you gave a good coverage of the legal perspective and the internal perspective of the government and the court. I wonder if you can elaborate a little bit about how the international community views the situation versus how the government sees it with regard to the classification of the conflicts on the one hand, and with regard to the human rights issues that you refer to. I mean, special rapporteurs and after reporting NGOs. How do they refer both to that classification of the different conflicts or almost conflicts that you have, and the human rights situation?
Thank you for a very good question. Through my study, what I found that I could not find any of the NGO which is talking about the actions taken by government in such kind of violence. And their approach, it found to be kind of constantly maintaining the same status. That there are extrajudicial killing, there are disappearance of the people. So all burden was from the NGOs shifted towards the government without, I read certain news clips also, then because it was mentioned in one of the report of Amnesty, then I looked into the report. There was no substance which can connect that government is responsible. So from coming to that how the world community look at it, that depends on country to country and the people, what kind of, if I may use the word narrative, am I going to the direction which you expect? Or I missed the question.
I think how the international community
perceive
sees. I mean, you have the Human Rights Council, you have the rapporteurs, you have the High Commission on Human Rights in the UN, you have different NGOs that definitely look into the situation in India, and I wonder if they agree with the Indian government about the classification. That is, there are internal disturbances, or might be non-international conflict or international conflict, as we said. And with regard to the enforced disappearances, for example, they say there are claims, but Amnesty International doesn't provide connection to the government, right? But isn't it up to the government to take those claims, actually investigate them? So are they following through?
The government through army investigated around more than 200 cases, but 150 people were convicted till date for the kind of violation, or they are going beyond their jurisdiction. So that is the one aspect that where the government or the army is taking action on the people who are erring on human rights. Now coming to the international institutions, they have a continuous single approach which is always showing a kind of negative light on the conflict. I could not find any improvement in their report. Like I shown that improvement at the ground level. that in 2009 or 2005, that was the biggest internal security challenge. And in 2020, that it has decreased up to an extent that within few years or within next decade, the problem will be over. So they are not showing that. They always show that it is a negative kind of thing, and the way they present it looks like that, as the government also says, that it is a interference in the internal affairs. So that's what I found a perspective of international institutions or organizations. Recently, a human rights that UN report here, they have also published a report. Then in that report, they have not shown any good thing happened in JNK. And it is quite visible that recently, just 1 month back, election took place. And people were standing in lines to cast their vote. That was not happening in JNK. If the insurgency is still there, then people would not have come out. The investment, level of investment is going in JNK. That shows different picture. So a kind of narrative-based approach I found. Obviously, government always, wherever we go, governments used to keep a status quo in their position that they are maintaining whatever they are saying. But the non-governmental organizations at least should change their stand according to the situation, and that is not available.
Yeah. So it was connected about the qualification of the conflict because I think especially when you are shown the map with such a huge corridor in the country, the geographical scope of the qualification of the conflict is key. So I want to ask you whether you regard the situation as an internal armed conflict in the whole corridor, or whether you want to distinguish it. And because it's probably under IHL there is a need to identify the geographical scope of the conflict. And then the other point is whether you think that under the effective control or overall control test, there could be an international armed conflict in Jammu and Kashmir, whether the assistance support by Pakistan would meet the requirement for the qualification of the conflict as an international. So whether to distinguish the situation over there in terms of the qualification of the conflict.
There are two aspects when we look at the qualification. One is, how do we call it, internal armed conflict or internal conflict, or we can say internal security challenge. So that perspective, look at that, whether there is direct fight going on between one country and another country on particular area. So direct fight is not going on. Although there is contentions from Pakistan side and from Indian side that this area belongs to us, that area belongs to us. But direct fight is not going on nowadays. And the area which is falling within the boundary of a country is internal area. So if we call it an international conflict, then the international players got a right to interfere on the ground of humanitarian intervention. And if we declare it non-international armed conflict, then also the international agencies and NGOs, they got a chance to publish report, although still they are publishing. So from government side, the government don't want to get interference from external affairs, external players. So that is why they have declared it a kind of not to call it armed conflict. But what I felt it with looking at the geographical spread and the kind of consequences are coming, most of the conflict are rooted in local conditions. And that these local conditions has a direct connection, which I also discussed in my paper, that developmental level of that area. If the area is developed, there is peace. So that is the problem.
Sorry, I think I lost you here for a second. Can you simplify it for me or repeat? The issue should suggest that the classification of a conflict as an international necessitates or opens up possibility of external intervention, or did I get it wrong?
Yes, it opens.
Why would that be?
Because when you declare a particular area as international or area affected by international armed conflict, then it is not within the boundary of that country. So it is having a kind of scope where the agencies. Yes.
Declare area.
Means country.
You have an international conflict, you have an international conflict.
Yes.
If you have a non-international conflict, you have a non-international conflict.
Yes.
Usually it's a matter of fact. It's not a, unless we're talking about nuances, it's not a decision of the government. We're going to choose this body of law and not this body of law because, well, you could argue that the state would have, in certain circumstances, a preferences to say, yeah, well, let's say this is a non-international conflict. Yeah, let's kill them all. No human rights, strong restrictions don't apply as much as regard to the right to life anymore because we have that speciality for international conflict and all that framework. So it shouldn't work like that. That you right. Choose your legal framework and then justification of situations.
Maybe my understanding is limited, but what I saw that even that parties to any covenant, when they sign it or approve it, ratify it, then they are bound by the legal provision. So when a particular country is declaring that this is armed conflict, then it is an open invitation to the concerned agencies to look into the matter. Isn't it? If I'm wrong, you can correct me.
Quick follow-up, just with regard to the situation in Kashmir.
Yeah.
It's not a matter of deciding whether Pakistan has a right to intervene, but whether Pakistan supported in a relationship of agency the insurgents. If that's the case, then you could qualify, depending on the effective or overall context to whatever is debate here, the conflict as being international in nature. But it's not a use of venom issue. It's not it's just an objective assessment of the relationship of agency between the insurgents, potential relationship of agency, insurgents and the foreign country. So that is what I was looking into. Could you still call it? Could you still take the view that Pakistan controls the insurgents?
In JNK, it is JNK means Jammu and Kashmir. The situation is a bit different compared to northeastern part of it, where small groups, tribal affiliation, due to their narrow ethnic nationalism, they are raising arms. But in Jammu and Kashmir, this is not the situation that people are forming a group and that group is fighting on behalf of. Here individual terrorist groups are coming. They are attacking civilian as well as the government institutions. So there is passive support, which is from domestic perspective as well as you can see that instances where have direct connection, like recently in 2019 that Uri is a place where the Pakistani side supported certain terrorists and they came and attacked. So what I'm saying is that evidence of connecting the terrorist with Pakistani support bring me to that conclusion that it is not a kind of insurgent activity which is based on people's movement. So that's what I think. I have not looked into that much in that area, how to qualify it, how to look, so that may be a limitation of my responses.
Thank you. I also had a question about the classification because it's just like a given legal framework, the legal straitjacket, if you want to classify the situations. And I were, in this light, as I understood, there are multiple armed groups involved. Also, some are different in their organization, and whether additional protocol 2 applies would be very important to identify, I think. And the other thing would be, you mentioned a very interesting example about the mingling of civilians, right, with the armed forces. And there you also mentioned something about the family members. Would you then also be considering the continuous combat function, you know, as a tool to maybe allocate the status of a fighter versus combatants, you know, based on the customary international humanitarian law? Thank you.
I made a mistake of using the terms very loosely. So I should have been careful about it. So from that perspective, I need to study a bit more that whether that particular term can be given or not given, and what would be the consequences of giving that term.
Because I think, may I just very quickly, I think when you deal with the terrorist armed groups, the question is always, how would you classify the situation with the involvement of the terrorist groups vis-a-vis the state armed force, you see, and whether IHL would apply to the terroristic act, you know, so what's the terroristic act, and whether a terroristic act alone necessitates the application of humanitarian law, or whether it can serve as a ground to start an armed conflict. So these are, at least in my knowledge, and please correct me if I'm wrong, you have two, you know, strands of argumentation going. One that's saying that, you know, terroristic act is solely the action of to be regulated by the internal criminal law, and if there are certain facts falling under the ambit of Article 3 Common plus additional Protocol 2, then you are talking about the armed conflicts censorship. You see what I mean? So Sassoli has written a very small piece, which is a guiding piece for me at least, saying, you know, whether the terroristic act can be a trigger of an armed conflict, you know, like the war on terror narrative. This is just something, maybe I'm wrong, maybe I'm not thinking the direction I should be thinking, but I guess, you know, maybe you could.
The word terrorism has not been defined, I think, universally or having a common definition. What would be terrorism? Although there is some international resolution of, I think, if I'm not wrong, General Assembly resolution of 2000. So, but it has not been defined. What would be terrorism? Unless and until something is defined or given a particular meaning, we cannot come to conclusion whether the terrorism or people who are terrorizing and can be given certain status or not. And another thing which you mentioned, that if it becomes a triggering point, that one person's terrorism becoming a triggering point for the people are coming for militancy. So that is not the case. That, for example, in a northeastern part of India, where the militancy began with the narrow nationalism of tribal people. Like if there is a small tribe of having a population of 2-3 villages or 500-600 people, they started declaring themselves as a country. And not only this, they have started killing each other, the neighboring tribes. So that forced the government to bring a law in 1958, that is Armed Forces Special Powers Act, and deployed army to protect them, to protect the victims from these inter-tribal wars. Later on, these groups came against government in order to declare their own, or in order to seek their autonomous status. So that is how things turned in northeastern part. But Kashmir, we have never seen such instances where the public is coming behind a particular group. Yes,
just one comment before the program. India is not party to the additional protocol.
yes, additional protocol. I mentioned that in my presentation.
So,
I'll just,
and I think
because the legal.
this discussion would be uncustomary rather than really all the actual law, which is much more interesting, actually. As well, right?
So I know you've been fascinated by this topic for quite a few years now, and I wonder whether since about 2019, when we first talked about it, in the course of the two elections that you had in India, you're seeing any kind of change in terms of the largely political understanding of the conflicts, the formal definitions, which obviously we can't argue about, set aside.
The number of casualty of civilians have decreased a lot. Decreased. So that shows a positive improvement. Not only this, the kind of complaint we used to see against army has also decreased a lot. For example, in 2017, there were 29 complaints for human rights violation by army. In 2018, there were 42. Then in 2019, 26. Then in 2020, 7. And in 2021, 4. So up to 2021, I have data that is showing a drastic decrease in complaints. Not only complaints, but even deaths have decreased. But you were mentioning that in 2019, I gave a presentation. In 2019, I was discussing the framework which deals with internal security. That was the only legal framework. So here I'm looking at that how the civilians are impacted, how the developmental initiative which took place in all these years, how that from coalition era to that one party government, how that is changing the whole ground reality of the internal conflict in India. So a big change I'm seeing is a continuous decrease in casualties of army, of paramilitary forces, of civilian in that area, and very limited number of people nowadays joining these militant groups. So earlier the tribal people used to go in that area. There is a big shift in the approach of tribal people from the central part of India. Now they are not becoming part of it, they are becoming part of government initiative. And at ground level, I visited certain tribal areas. I have seen that the basic infrastructure now is in much better condition. So that basic infrastructure is giving them hope. Now the schools are running. Earlier the schools were utilized even till 2019. There are cases where the schools were occupied by the militant groups. So the positive development is now they are pushed into jungles and the villages are free from there. That is it.
And just on the complaints, I mean, the complaints are kind of problematic indicators from my point of view because it could be systemic barriers that prevent people from articulating a complaint or from that complaint actually going through. But the number that's convincing me is the actual number of deaths because I trust that it would not just be state statistically precise, but you'd be looking at something else as well. So thanks for that because it's actually a really positive outcome.
And this is just a question also on this data. So again, the death statistics are maybe more plausible. The number of complaints dropping that strikingly in 2020. I mean, to what extent can this just be chalked up to some equivalent like a non-response because of COVID? All right, are there? It just seems like there's such a reservoir of data and factors behind the scenes that could also explain this to a large extent. You know, there's fewer interactions between military and civilians, or what have you, due to lockdown or isolation restrictions or what have you. So, I mean, though it dropped a little bit from 2020 to 2019, having a dramatic fall off of any data set in 2020 seems like there maybe is a much easier explanation than the actual shifts. So I don't know if you have any more info on the actual sort of stats surrounding this. I'd be interested, because otherwise it just seems like you can't directly extrapolate a political shift as the cause behind that.
Actually, this data was submitted to Parliament. So, in press briefing, government may lie, but when the opposition parties are seeking that data, they cannot submit the fake data or wrong data.
I'm not saying it's fake.
Another thing is that
So there is noise behind.
yeah.
Yeah.
Yeah, there are so many variables.
Yeah. So another thing is that ground reality. I'm not going just by the data provided by agencies. You can also check with the internet. Forget about going on the ground. I have gone on multiple places which were earlier affected by the militancy. So just 2 months back, I went to state of West Bengal. There are certain areas which were earlier having or facing a kind of fire from the Maoist insurgents. Now it is not. So same is situation about the northeastern part of India. Many agreements signed with the militant group. They were now, being assimilated with the mainstream. So that agreements, ceasefire agreements, all these are showing a positive hope. Moreover, government may hide data, but the instances they cannot hide. It will come to news. For example, I think 2 years back, around 10 civilians were killed in one of the northeastern states because of wrong info received by army. They heard that militants are going in the bus. They fired at the bus. Later on, it came to know that they were civilians. So instances are coming, but the number of instances have decreased. But I certainly will include that data.
Yeah.
We'll try to make it
plain data tracking. It's so hard to pin down the whole explanation. But
So we have electronics speakers, we have Laura, we have Nadia, we have.
I have a question, a really quick question to the Special Powers Act. As I understood it right, that these areas are declared as disturbed by the government.
Yeah.
Is there any mechanism or tribunal that watches over those declarations, or?
No, there is no tribunal. Actually, when the area is facing some kind of law and order problem, or that area, for example, the normal law and order is not there, or it is disturbed up to that extent that police forces cannot work. So in those situations, usually if it is in the control of the state. In India, we have a kind of arrangement like 28 states. Then we have certain union territories which are in direct control of union. So in states, the executive head is governor of the state. In union territory, the executive head is the administrator of the union territory, who is appointed by central government. And the specific areas where the central government have direct say. So in those aspects, so the central government take a direct call. So the declaration of the area dependent on the factual condition, and that factual condition is purely a discretionary area of the court. So there is no tribunal, there is no fact finding of the area whether that area should be declared or not. So criteria is not there. The only thing mentioned is the severe kind of law and order situation. So that's what I was saying, that the loose language used or the wide words of wide amplitude are used in the laws. So that is an area which should be interpreted or explained in these laws. That is what I recommended in my suggestions.
Just two finger on that. These disturbed areas, the application of the Special Force Act, it's essentially some kind of declaration of martial law for those areas. And the fact that the military has to be used as opposed to the police force could be an indicator for it being actually a non-international armed conflict. Now, those can end at some point. You've been, in your answers, on one hand you talk about armed conflicts, on the other hand you talk about peace or ceasefire agreements. Are these still armed conflicts then? But do they remain under the power of the special forces indefinitely, or how does that work?
The ceasefire agreement?
If there's a ceasefire agreement, does it cease to be a disturbed area?
No. The seizing of an area as disturbed area is only after the declaration by notification of the government. If the government is notifying that area, for example, certain area is in the state of Arunachal Pradesh, which is having border with China. So certain areas, earlier they were under Disturbed Area Act. Now it is not. Now the government has declared that this area is no more disturbed. So the moment it is declared that it is not a disturbed area, then there would not be any application of AFSPA, Armed Forces Special Powers. And what you were mentioning that whether ceasefire or agreement provides an opportunity. Yes, it provides an opportunity, but they will observe for a certain period of time. If there is no conflict, then in coming time they will declare that area as free from that disturbance. So that is an initial step that they will check. They will not attack each other. They will wait for some time, and then after that they will declare that okay, this is now an area which is not disturbed.
Just very briefly on AP2 application. Yeah, maybe India is not a party, but within AP2 there are, well, at least some people believe that AP2 still contains customary law rules, you know, and could it be applicable on that basis and de facto? Because these corridors, these corridors and the armed conflicts that are going on in that, you know, strip could also mean that, you know, there is a certain level of territorial control exerted by the armed groups, no? Or am I mistaken? So application of AP2 on a de facto basis is based on the customary law. Yes, a state may not be a party to it, but still, most of the rules contained in AP 1 and 2 fall under the customary law status. Not all, but most.
It's just another fascinating aspect of statistics and numbers. I was also wondering about the number of deaths. You might have clarified this, I may not just catch it, but is it a sum number or is it a ratio? Meaning, is it a sum number, so the total number of civilian deaths, or is it a ratio? So vis-a-vis the death of combatants, this is the ratio of civilian death. The reason why it is important, I think, because you mentioned that in the early 2000s there were more military operations. So obviously more military operations, higher sum number. Late 2010, less military operations, less total sum numbers. So did you actually try to verify the meaning of the figures with a critical approach? Is it a sum number, is it a ratio, and what's the relationship between the early 2000s higher military operation numbers to the lesser numbers of late 2010 operations?
I need to add verified data, which I don't have right now on that aspect. But my observation on that is that even in operations which were taking place in 2005, 6, 7, 8, no doubt you are right that number of operations were more, and that was the reason that number of casualty was high. But at present, the operations are more successful compared to that. Like in 2009, 76 paramilitary forces personnel were killed in one attack. So that kind of thing decreased. The number of governments casualty decreased because of the intelligence, because of the bringing people towards the government side or creating them a kind of soft corner for the government in the mind of public. So that helped a lot. So the ultimate purpose is not that to bring down the casualty. Ultimate purpose is to bring the peace. If peace is there, the conflict would not be. The conflict would not be. Ultimately, there would not.
That is not an IHL argumentation. So it's not a legal argumentation.
From international perspective,
it's not an IHL approach. It's not a legal approach.
Yeah, that's what I am discussing in it. Specifically the Indian context, international context, I really need to work on. I accept that. But from domestic perspective, from legal perspective, from the judicial response of India, because it has not been declared as I mentioned in that India is not part of additional protocol. So India has stopped the application of international law. Although international law, like Nadia mentioned, that customary law is still applicable. But the data you mentioned, I will look into the data and add it in.
You mentioned, I just clarified it.
The last comment. Isn't it the reason why we have international law? So that not to allow states to,
yes,
instead of the,
for that I have
well-established international,
I have added some
their own security or non-security based on their political assessment.
The problem with the conflict of international and the municipal law is that international law has been applied in a so selective manner. Nowadays, countries are trying to avoid whenever it is affecting their interest, instead of going by the good objective or good spirit behind the international law. So that is one of the reasons. So from last 70 years, just have a look at how the international community has responded to India's outbreak. It looks like that the response of international community is promoting the militants instead of helping them, instead of bringing programs to train the forces, to train the administration, to provide certain economic resources so that peace can be established. The only thing is not that to designate particular area as a conflict and just talk about human rights, not to resolve this. So it may not be an international law perspective, but laws are for ensuring justice, ensuring peace. Law is not the ultimate objective. What the law are going to deliver, that is the ultimate objective. If laws are not able to deliver, then having certain instrument is of no use.
Thank you very much, Rajesh.
Thank you.